when it comes to the practical implications of who's on that list for
Yeah.
retroactive application of the ZPO, all those people are going to be left off the list, right?
Correct.
And it's because the commission is the one that's going to be compiling this list of
Yes.
every person they think this retroactively applies to. So lawyers, clients, if you're not on that list, it's probably because the commission saw you got a leader organizer enhancement and they say, nope, we don't want those people. So we're headed for a fight.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you from his lovely backyard, I guess, in Scottsdale, Arizona, because I'm not in Studio 3553 this morning, and that's my dog Zippy weighing in because it's 7 in the morning and it's Saturday, and I'm here with my good friend, colleague, Mark Allenbaugh, to discuss a very important aspect of the new sentencing guideline amendments. And so, boy, oh boy. Okay. So hi, Mark. Good morning, Mark Allenbaugh.
Good morning. Good morning,
Doug. Yeah, this is a fun tradition we're starting because we did this last week too.
Yeah.
But it's not quite as early for you because you're an East Coaster type person. But anyway, here's the deal. We know that the 0-point offender amendments to the guidelines are going into effect in November, barring some active nature.
Well, Congress can't act. They don't have a leader. There's no Speaker of the House. So we know it's absolutely going into effect.
I didn't even think of that.
No speaker, no legislation, no way to veto, So this is absolute. All these amendments are absolutely going into effect.
I mean, I suppose we could have a longer conversation about whether we think they're going to have a leader by November 1st. I mean, but that's less than a month away. So my money's on. Yeah, good luck with that. But anyway, so the big one that's going to affect the most people is the 0-point offender, which we affectionately call the ZPO. And we know that it's retroactive, and there are thousands of people who are facing sentencing now who are already sentenced who could be eligible for this additional 2-level guideline reduction, which is significant. But we have a rub. And that rub is what they call Criterion 10. In other words, ZPO carves out some exceptions to say, if this, if that, or if this, you may not be eligible. And the one that's sticking out, that's going to be the one that's kind of the stumbling block, or at least a perceived stumbling block, is Criterion 10. Just tell me, do you have it handy, the language?
So Criterion 10, I have all 10 criteria listed here for the ZPO, which is going to be under new section 4C 1.1. And so there at the bottom, it's highlighted. The defendant did not receive an adjustment under 3B 1.1, aggravating role, and was not engaged in a continuing criminal enterprise.
Okay. So that was a fine dramatic reading with the emphasis on and, because that's really at the heart and soul of what we're going to be talking about. But here's the thing. We have to confront this head on. Lawyers, clients need to understand, because a lot of people get a leader organizer enhancement in their guideline calculation. And a lot of lawyers will look at that, look at Criteria 10 and say, game over. And we're here to tell you it's not game over. We have a strong argument. Well, you have a strong, I'm not going to take credit for it because you're the legal genius in this dynamic duo. Everyone knows that. But we have a strong argument that even if you get it or got it, the leader organizer enhancement, you may still be eligible. So this apparently rises and falls about whether and means or. And I feel like this is a very Bill Clinton-esque, depends on what your definition of is, but break it down. What's the issue of, I guess statutory interpretation isn't the right word, but
actually, this we are going to talk about it. This does go down to this does involve statutory interpretation because of where the commission pulled this language from, and they pulled it from the safety valve, and we'll talk about that. Safety valve is at 18 USC 3553 F.
Okay.
We usually talk about 3553A, but this is 3553F.
So anyway, safety valve comes up in drug trafficking, drug cases, right?
Correct. And what the safety valve is for low-level drug offenders, or low-level drug traffickers, if you will, generally mules, those people that were just used to transport drug amount, but they're not the distributors and leaders and all this other stuff. They're just like, low levels folks. The safety valve was created by Congress, and it allows judges to sentence below an otherwise applicable mandatory minimum. And this often happens because this goes back to when the guidelines first began. There's the sentencing guidelines, which originally were mandatory, but now advisory. And there's also mandatory minimums. And many people sometimes confuse this, especially if they're new to the guidelines. Mandatory minimums are different from the guidelines. They trump the guidelines, but they have nothing to do with the sentencing guidelines per se. They are creatures of Congress, not of the commission. And so what happened, and what still happens, is every now and then when a judge calculates the sentencing guideline range, that guideline range may be below the mandatory minimum. So the commission is telling the judge, hey, you should sentence down here, but Congress has trumped that with this mandatory minimum. And so what Congress did was create this thing called the safety valve, which in certain circumstances allows a judge to ignore that mandatory minimum and go with the guidelines. Okay. And now that the guidelines are advisory, they go really far below.
And this is an important discussion because this issue is coming really, really a hot topic when it pertains to the safety valve, because it is the exact same language and because people are fighting over whether and means or, and that fight has made its way all the way to the Supreme Court. And last week they had oral arguments in a case called United States versus Pulsifer, or is it Pulsifer versus United States? I don't know which way the caption goes. So we just had oral arguments at the Supreme Court. Yes. And we're trying to read the tea leaves, because if that case breaks in the way that we think it should, that's going to go miles and miles to help us with our argument on Criterion 10, right?
Right. So let's just to be clear here. So what exactly is the issue with Criterion 10? There's two ways to interpret the way it's written. One way is that if you have either an aggravating role adjustment, meaning you are a supervisor, manager, or leader in any kind of conspiracy, that precludes you from eligibility for the ZPO, okay, and also for the safety valve, but that's a different issue for our purposes. But that would preclude you for the ZPO. Or so it's either the one way to interpret Criterion 10 is you can't have either the role adjustment or have been engaged in a continuing criminal enterprise. Having one or the other excludes you. That's one way of interpreting it, and that obviously is going to reduce the number of people who are eligible, because basically then under that interpretation, anybody who has a role adjustment, and it doesn't have to be in a drug crime, it could be for any tax, fraud, whatever it is, they would be ineligible for the ZPO. The other way to read it, I think the correct way to read it, as we'll discuss, is you can't have both at the same time. In other words, it's meant to exclude those individuals that received a role adjustment while in the course of a continuing criminal enterprise. Right. Only if you have both criteria at the same time are you ineligible. But just having one, if you just have the role adjustment, but you were not engaged in but you also were not engaged in a continuing criminal enterprise, that's not going to exclude you. Just having the role adjustment alone is going to exclude you. You also have to have been in a continuing criminal enterprise. So those are the two ways to read it.
And this is a perfect example of why people hate lawyers, because if you look at the language, the word is "and" in there, correct? Okay. Correct. So if you read it on its face, it means this and that. And they're saying the commission is saying, well, we really shouldn't read that as saying this and that. We should read it as saying this or that. You only need one.
Right. Exactly. That's exactly what they're saying.
So we're gonna have to talk about why they think and doesn't mean and. But I do have one question that came up, and we haven't discussed this, and I don't know if I'm putting you on the spot, but does any of this rise and fall under what the definition of continuing criminal enterprise is?
No.
Okay. No. I mean, because do we even know, is that defined anywhere? Is that just sort of
continuing criminal enterprise is defined at 21 USC 848. I mean, that's actually stated in Criterion 10. Criterion 10 states again, the defendant did not receive an adjustment under 3B 1.1 and was not engaged in a continuing criminal enterprise as defined in 21 USC 848. So that has to do with drug offenses.
Drug trafficking,
Drug trafficking, exactly. And my argument is that Criterion 10 only excludes high-level drug traffickers or management level drug traffickers.
Okay.
That's it.
Well, that's a very simple way to state it. So I'm glad you did that. So that's a good starting point.
And just for everybody out there, let me define continuing criminal enterprise. And this is, again, at 21 USC 848 subsection C2 really is the meat of it. It says for purposes of this subsection, a person is engaged in a continuing criminal enterprise if he commits a drug felony, and such violation is part of a continuing series of violations which are, and this is the key point, which are undertaken by such person in concert with 5 or more other persons with respect to whom such person occupies a position of organizer. So that it makes it very clear then that the continuing criminal enterprise is you are involved. You already are basically an organizer of some type of So you're going to get that. You're going to get that enhancement automatically under 3B 1.1 anyway. If you're engaged in the criminal, so I mean, this just reinforces my interpretation. That this is supposed to apply only to, supervisors and up in a drug conspiracy.
And that makes logical sense to me too, because the whole reason you want to basically punish people in drug cases is the higher up you go in the chain to management, leader, organizer, the more culpable they are. And the way that our federal law is designed is lightning, gravitates towards modes of least resistance. It's always the low people on the totem pole who are getting the brunt of this. And so they built an engine that says we want to punish the higher level people more. That does not translate when it comes to these white collar offenses where there may be a couple people, involved in it, and all of a sudden you get a leader organizer. And it doesn't translate to the heart and soul and purpose of the ZPPO, in my opinion, which is to say, you've never been in trouble before. You've done something bad. You've made a mistake, but we're going to recognize the fact that you have 0 criminal history, and we're going to acknowledge that. And it shouldn't matter, in my humble opinion, the slightest bit whether, where in the ladder you fell of culpability. It just doesn't make sense. It seems totally in conflict with the point of the ZPPO to me.
And you're exactly right. I mean, that the point of the ZPPO, what the commission realized when they were doing some empirical studies on criminal history is that those individuals with 0 criminal history points have a substantially lower rate of recidivism than those even with a single criminal history point. I mean, they don't have to be true first offenders, but they just don't have, they cannot have any scorable criminal history. And just that alone, there's empirical studies by the commission itself that say, hey, these guys are a lot lower, or a lot less risk of recidivism than even those with a single. So they should, and we treat them the same. Right now, the guidelines treat, or traditionally we're treating those with 0 criminal history points and the single criminal history point exactly the same. And so the commission say, hey, we got to give some consideration here for the 0 point offenders. And so that's where the -2 now comes into play. But to your point, and the reason why my reading makes sense too with the continuing criminal enterprise is because the continuing criminal enterprise, by definition, is a continuing series of violations. So there's like a built-in criminal history there, if you will. You already have to have been engaged in not just one single offense, like many white-collar offenders are. This is just a first-time, bribe or a particular fraud, took place at one particular time. It's not a continuing violation or a series of violations that's built into that very definition of continuing criminal enterprise. So these individuals would not fit into the mold of the 0-point offender, or they would not fit into the empirical studies, if you will, that the commission found. They would not be true 0-point offenders. They would have a different makeup, different characteristics than what the commission found. And my big final point here is, if the commission wanted to exclude individuals just because they got a role adjustment, first of all, that doesn't make any sense empirically. What is the relationship between a role adjustment and recidivism? There are no studies on that, to my knowledge, and the commission didn't ever point to anything like that.
Right.
But also, but if the commission wanted just to exclude that, then they wouldn't have had any of that criminal history or the continuing criminal enterprise talk in there. They would just say Criterion stands would just say, if you got a role adjustment, you don't get the ZPPO. That's it. That would have been clean and easy, but they didn't do it. Because they pulled that language from the safety valve, and the safety valve is applicable basically only to drug offenders, it makes it very clear.
Yeah.
The whole
but we
history.
do have a problem, which is to say the commission itself is saying that's not what we meant. So they could have done it. They should have done it.
Binding.
I know. But we'll talk about this, because when it comes to the practical implications of who's on that list for retroactive application of the ZPPO, all those people are going to be left off the list, right?
Correct.
And it's because the commission is the one that's going to be compiling this list of every person they think this retroactively applies to. So lawyers, clients, if you're not on that list, it's probably because the commission saw you got a leader organizer enhancement, and they say, nope, we don't want those people. So we're headed for a fight. Now, don't wait around to be expect to be on a list somewhere. You got to be proactive about this. And a lot of times your clients don't know if they got a leader organizer, they don't remember. And so a lot of this is on lawyer leadership. Somebody's got to figure this out. Or call us, but sentencingstats.com is right behind you. There it is. And 0pointoffender.com we have. But this is we just mentioned this a little earlier. This may rise and fall over the Supreme Court's determination of similar language in Pulsifer. You told me that you listen to oral arguments Monday, and you're even more confident after listening to that. Here's my full confession. I started to listen to the oral arguments. So, because you can pull them free on the Supreme Court website. And so I was surprised that there was like an hour plus of thing. I didn't think our oral arguments lasted that long.
They generally don't. They're only about 30 minutes.
And so, but I confess, like, I only got through the first 20 minutes of this hour plus oral argument. And my observations were as follows. It was a mind-numbing discussion. Like, I cannot wish for that, like, 20 minutes back in my life. And like, I'm trying to think of better ways that I could spend my time, and like jamming sharp pencils in my eye sockets, maybe, or sliding down a hill of gravel with no pants on. Like, anything would have been more fun than listening to these. It's
very graphic, Doug, but okay.
Like, it was fucking torture. I'm sorry, but that's how my brain works. I'm ADD, and there's all this M dash and superfluidity and distributive and all this terminology that was and so I quit. But what I did here was, I guess, just from what I saw, I wasn't as super rosy positive as you. Like, it felt like even some of the lefter leaning judges, like Justice Kagan, were kind of given a hard time and presenting these hypotheticals about and or.
Let me give you a hypothetical and tell me if you think it falls into that category. So you're going in for a medical test and you receive something from the hospital. And it says to receive this test, the patient should not, and then, it has like a list of things that the patient shouldn't do. And it says the patient shouldn't eat any food, drink any liquids, and smoke. So I'm going to assume, Mr. Dvoretsky, that you're not a smoker. Do you feel perfectly able to eat and drink as much as you want?
Because you don't smoke.
No.
I didn't feel as good about my 20 minutes, but you did the deep dive.
Yeah.
And for the record, people may not know this, you're going to tell us this is a lot about logic.
Yes,
and
De Morgan's laws.
And for people who don't know, one of Mark Allenbaugh's many achievements in this lifetime is he used to teach logic at George Washington University as a college student, which I think is as a law student,
Yeah.
which it's kind of cute because I'm wearing my Washington University sweatshirt as we record this podcast. And of course, that has nothing to do with George Washington University. Anyway, I feel like I've gotten us off track. So anyway,
no problem.
why are you so optimistic after listening to the oral arguments in Pulsifer?
Because because unfortunately, Mr. Pulsifer is going to lose, and we want him to lose. Because if he loses, then my interpretation, and if the government wins, and this is the good thing, the government wins, then we win. My interpretation will be validated. So let me just kind of go through this, if I could, just real quick. And this also is important for those out there, just on the safety valve. Just forget about the ZPO for a minute, but just the safety valve alone, because the safety valve has changed quite a bit. And this is another important, in light of the First Step Act, and this is something important that those that represent drug offenders should be aware of. So what we have here on the screen is the old version of the safety valve, and there's the five classic criteria. The first one was the defendant does not have more than one criminal history point, and no violence or use of violence, no death resulted. Then famously, as we're going to discuss some more, criterion 4 in the safety valve says the defendant was not an organizer, leader, supervisor of the offense, and was not engaged in the continuing criminal enterprise. So there is where criterion 10 comes from. And then the fifth was that the fifth criterion for the safety valves, that they fully and truthfully debriefed with the government about everything in the offense before sentencing. What the First Step Act did is expand the application of the safety valve, because what was happening, it's that first criterion in the safety valve, that if you had more than one criminal history point, so in other words, if you were in criminal history category 2, 3, 4, and up, you were not eligible for the safety valve, even if you met all the other criteria. So it was very limited in that application. So what the First Step Act did is it expanded it by changing that criteria now, by changing criterion 1, and now you are only excluded if you have more than 4 criminal history points, or a prior 3-point offense, or a prior 2-point offense. And you'll see, for those that are watching on YouTube or what have you, this "and" here that I've highlighted in the new provisions of the safety valve. It's that "and" that's been screwing everybody up. How to read that "and"? Now, what Mr. Pulsifer has argued is that the way to read that "and" is that each of these criterion, or each of these criteria must be met. In other words, only those individuals that had 4 criminal history points for a prior offense, and also had a prior offense that was a 3-point offense, and also had a prior 2-point violent offense. So basically 3 offenses, only those individuals were excluded. And that really limits the exclusion, if you will, or really expands the application quite broadly. as the government pointed out at our oral argument, to have to meet all three of those criteria at the same time is exceedingly rare.
Yeah.
It's exceedingly rare. And so what the government argued here is that and doesn't mean literally and. What it means is or. And the way to read this. In other words, you did not have either a 4 criminal history point offense or a prior 3-point offense or a prior 2-point violent offense. So you did not have more than 4 criminal history points, excluding any 1-point offenses, or you didn't have a prior 3-point offense, or you didn't have a prior 2-point violent offense. Having any one of those, so if you had more than 4 criminal history points, you don't get it. If you had a prior 3-point offense, you don't get it. If you had a prior 2-point offense, and it was violent, you don't get the safety valve. And that's the way the government reads it. And of course, Mr. Pulsifer, I think he met one of these criteria, not all of them. And so what he's arguing is that you have to have all 3 in order to be excluded. So, and this is just from oral argument from his attorney. He starts out, the natural reading
of section 3553 F1 is that and means and. It joins together enumerated criteria. To be safety valve eligible, a defendant must not have A, B, and C, all 3.
All 3, he should have added at the same time, which is really what he meant. But what the government argues is no, they get into the discussion about the distribution of the conjunctive, or a distributive and. That's just a fancy.
See, this is what I'm talking about.
I know. So that's just fancy. So what does that mean in English? It means or. It means or.
Okay.
And everybody got caught up on that. I don't know why Mr. Liu, who argued on behalf of the government, just didn't say, judges, this distributive and just means or. That's really what we mean, because that is what they argued, and the court actually pointed out. And this, by the way, comes from the 8th Circuit. This is an 8th Circuit case. That's what the government argued below. It just says, and really means or in this context. And the government actually, so I just want to read this one more part here about what the government argued at the beginning, is what is inexplicable.
What's inexplicable about petitioner's reading is that it would disqualify only those defendants with a rare combination of characteristics, including a prior violent offense of exactly 2 points. So a defendant convicted of a violent offense would actually prefer to receive a longer sentence worth 3 points to avoid being disqualified. That makes no sense.
And the government's right. I don't think Pulsifer is going to win here.
Yeah,
I think Pulsifer has a bad argument, in that in this context, and means or. And so let's get down to how
I can't wrap my head around the fact that of just drafting, like stupid drafting. Like why didn't they just say or? I mean, what is that just a mistake?
I'm going to get to that. And it is, in all honesty, it's not stupid drafting. It's just that English, this has really to do with linguistics and logic. Okay. And I don't want to get too much into philosophy yet, but really that's what it has to do with. So What I'm showing here is, this is Sotomayor. Now, this is where it really gets relevant. This is what I liked about the oral argument. Pulsifer is they're trying to figure out F1. Remember, and F1 is the what the First Step Act changed, and it provided basically expanded criteria. It's not limiting the safety valve to those with 1 or more criminal history points. You have to have all these three criteria. But this and stuff is what's hanging everybody up. The and also occurs down in F4, and F4 is criterion 10 for the ZPO. And this is what Sotomayor points out, and I love the way she reads it. When it wanted
to do a not in F4, it wrote, contrary to Justice Kagan's expectation, in a very cumbersome way. It said, the statute requires that the defendant was not an organizer or leader and was not engaged in a continuing criminal enterprise. I think she's right, and that's the way we want to read it. The 4th criterion for the safety valve, and I know this is cumbersome, and the 10th criterion for the ZPO only excludes those individuals that meet
both criteria at the same time.
So that sounds like the money shot, basically.
That's the
language
money shot.
That's exactly our language, and saying that's how it's supposed to be read in that instance.
Exactly. And then this is Justice Jackson, and she says the same thing. She also looks at F4.
I'm looking at F4 now, a circumstance in which Congress has repeated, the defendant was not an organizer and was not engaged in. So wouldn't we have expected for Congress to do that same sort of thing if it meant for these things to be distributed in one?
She reads that as the defendant was not an organizer and was not engaged in a continuing criminal enterprise. So both those things must be present. In other words, this person could not have been a high-level drug dealer. Like I was saying at the beginning, that's what excludes you from the safety valve under F4, and that's what excludes you from the ZPO under Criterion 10.
Okay, good.
So this is why.
That's why I have you.
So yeah, this is why I perked up when I was listening to the oral argument. Oh my God, great! They're talking about F4, which is Criterion 10. And so here's F4. When I keep talking about this is F4 in the
safety valve.
Safety valve. Thank you. And so again, you can see it's basically virtually identical language to Criterion 10. So defendant was not organizer, blah blah blah, and was not engaged. And so now here is the new.
Well, wait a minute.
Yeah.
Go back.
Yeah.
Because they specifically say was not engaged in a continuing criminal enterprise, as defined in Section 408 of the Controlled Substances Act.
Yeah. Section 408 of the Controlled Substances Act is 21 USC 848.
Right, but wait. And was not engaged in a continuing as defined. Oh, so the ZPO has the same language. Okay, I didn't realize that.
ZPO, well, that's my whole point.
Okay, I thought they just said not engaged in continuing criminal enterprise, but they say
as defined
in 21 USC 848, which is the drug statute,
right? Which I read from earlier.
Okay.
And a continuing criminal enterprise, it has 5 or more individuals in it, and it continues over time.
Okay, now this is a point where I tell you that my mind has definitely been changed, because when we were banning this around, and even we wrote an article, by the way. Well, it was you and me and Alan Ellis, and it was part 2. It was the only one I was involved in for Law 360, which I would like to put in the show notes. So I'm going to try to get my hands on that.
It came out yesterday, by the way. That article's published.
Yeah, I know, because I got a Google alert, because I'm so vain that I put my name in the Google alerts, and anytime my name or set for sentencing comes up. Anyway, the point is, even when we were arguing, I'm like, well, it's not frivolous argument. It's a good argument, but I don't know if it's a slam dunk argument. But now that we've talked through it today, and just looking at this language and looking at Pulsifer and looking at what these, it's a slam. It is you have to make this argument. It has to be done. And this is a very strong argument.
Yeah.
I don't know that there's ever such a thing as a slam dunk in our universe, but this is super strong. I'm convinced.
Yeah. There were some great comments in there about Criterion about F4, which again is Criterion 10 for the ZPO, by both Justice Jackson and Justice Sotomayor. They read F4 the same way I read F4, which is the same way I read Criterion 10.
Yeah.
Which only if you are a management level drug trafficker are you ineligible for the ZPO.
Yeah.
End.
I love it. So, boy, oh boy. All right. Well, here, let us summarize the big takeaways from our discussion today then. And here goes, and tell me if I'm missing anything. First of all, the commission is going to woefully underestimate who's eligible for this.
They've already woefully underestimated. They only estimated about 7,200 individuals, and a lot more than that received an adjustment.
And that is because they automatically exclude anyone who got leader organizer. Correct. Now that, in my opinion, is going to be the biggest hurdle. Is the commission's going to be standing up and saying, no, that's not what we meant. Yeah. And then who knows, they may try to draft some changes to it down the road. But the point is, we've got an argument to make. It's a strong argument, and everyone should make it. you're not going to make the list so you got to you got to be proactive and litigate this. There's
So Doug, if I may,
Yeah.
I'm sorry.
yeah.
So if you received a roll adjustment and you didn't make the list, that doesn't mean you are precluded.
Exactly.
So for those of you out there, or for those of you who have clients that are already incarcerated, or you're looking at sentencing coming up, and your client is otherwise eligible for the 0-point offender, no sex offense, no death or bodily harm,
violence,
no violence, and all that stuff. So if you're otherwise eligible, but your client has a leadership role, that does not exclude him unless your client is a management level drug trafficker.
Yes.
Then he's excluded.
Yes. And that's what we do. So if you need help with that, you got to reach out. It's 0pointoffender.com. You've created this free calculator to let people see if they might be eligible.
Right.
We're going to put the Law 360 articles on all this stuff in the show notes. We've done a few podcasts on this, but the most recent one that really digs into how the retroactive application of the ZPPO is going to play out is episode 68 of Set for Sentencing. So check that out if you haven't already. There's a link to the show notes. It's 0pointoffender.com. And then there's also, what's the other way you get to that site?
Amendment 821.com.
Amendment821.com. And as always, check out sentencingstats.com because that's Mark Allenbaugh's bread and butter, is the statistics work and the guideline stuff. So I think that we have covered it, and I feel like maybe we covered it in record time, but maybe not. But this was a way more stimulating engagement than listening to those 20 minutes of oral arguments. So thank you. Thank you for that.
Very good. Okay.
We'll talk soon.
Okay. Thanks a lot, Doug.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.